Welcome to the debate. We are diving into a cornerstone of American jurisprudence today, the Fourth Amendment's protection against unreasonable searches and seizures. This right is deeply historical, rooted in English common law and that famous maxim that every man's house is his castle, a principle brought into stark relief by the colonial opposition to what were known as general warrants and writs of assistance. Basically, tools that allowed British officials to conduct these unrestrained roving searches.
That historical fight against government overreach is absolutely crucial. But the real tension, and I think the heart of our discussion today, lies not just in the right itself, but, in how we enforce it in the modern era.
Exactly. Our focus is the exclusionary rule, the mechanism by which the Fourth Amendment is enforced. And we're debating its fundamental nature. Is this rule an inherent individual constitutional right, something necessary to maintain the integrity of the judiciary itself? Or is it merely a pragmatic, judge-made remedy aimed solely at regulating and deterring police misconduct?
I maintain that the exclusionary rule is an essential constitutional ingredient. You really can't have the right without the remedy.
And I take a fundamentally different position. I argue that the rule, certainly in its current and most rational application, is a limited, judicially created remedy. Its primary, if not maybe its sole purpose, is to deter future executive misconduct, and its application must always be measured by a pragmatic cost-benefit analysis. So my position rests on this foundational idea that the courts simply must uphold the Constitution. I mean, if the government can violate the Fourth Amendment to gather evidence, and then the courts turn around and use that same evidence to secure a conviction, the constitutional protection itself becomes, as the Supreme Court put it over a century ago in Weeks v. United States, essentially of no value.
The very first explicit recognition of the rule for federal courts came in that 1914 decision, Weeks. And the core principle wasn't really about, disciplining police officers back then. It was about the duty of judicial integrity, the court's obligation not to sanction or participate in unlawful conduct. If the courts allow the fruits of illegal conduct to be used, they effectively become partners in the violation. So this perspective argues that the exclusionary rule isn't just about police training, it's about preserving the structural integrity and, frankly, the moral authority of the judicial branch as the final protector of rights.
That rhetoric, the idea of judicial integrity, it's powerful, I grant you that, but I believe it has largely been overtaken by, the necessities of a functional criminal justice system. Modern constitutional theory, as established pretty definitively in cases like United States v. Calandra back in 1974, views the exclusionary rule very differently. It is not a personal constitutional right belonging to the defendant. It is simply, as the court said, a judicially created remedy designed to safeguard Fourth Amendment rights generally through its deterrent effect.
Okay.
So if the rule's just a remedy, then its only legitimate justification is empirical deterrence of police misconduct. And this requires a difficult and, often controversial balancing act, weighing the heavy social cost of suppressing relevant, reliable evidence, which, let's be honest, can lead to demonstrably guilty parties escaping punishment, against the benefit of deterring future police error. This pragmatic framework is what necessitated crucial limitations, like the good faith exception established in United States v. Leon in 1984. If officers reasonably rely on a warrant they genuinely believe is valid, even if, say, a judge made a technical mistake in issuing it, suppression isn't mandated. Why? Because there's simply no police misconduct there to deter.
I see why you think that, but let me give you a different perspective on this primacy of deterrence. To focus on deterrence alone seems to dramatically strip the rule of the very constitutional gravity that gave it birth in the first place. When we look back at the historical opposition to those writs of assistance, those hated, unconstrained general search mandates, the goal wasn't simply to punish the officer who executed the search. The goal was to eliminate the power of the state to conduct them entirely. The historical analysis stressed in cases like Matt v. Ohio was that the exclusionary rule is an essential ingredient of the right to privacy. The integrity of the court demands that we not incentivize the violation of the Bill of Rights by providing a reward, a conviction, for illegal conduct. If the judiciary focuses only on measuring police error, well, it sort of abdicates its moral and structural duty as the constitutional check on government power.
That's an interesting point, though I would frame it differently in terms of practical efficacy. If the goal is truly deterrence, we have to admit that exclusion is often poorly suited for the task compared to other potential remedies, maybe civil damage suits against the officers or more effective administrative penalties and discipline within police departments. Since exclusion is so costly, by suppressing the truth and potentially freeing the guilty, we must apply a rigorous cost-benefit analysis. The pragmatic shift away from the judicial integrity standard became necessary precisely because the deterrent effect is often, frankly, negligible. Think about cases involving government error outside of deliberate police malice. In Arizona versus Evans or Herring v. United States, the court found that when errors are due to bureaucratic negligence, say a clerical error in a government database that an officer relied on in good faith, the cost of suppression far outweighs any minimal deterrent benefit. You just can't deter negligence in the same way you deter willful, culpable police conduct. Limiting the rule to instances where deterrence is actually possible ensures we don't pay an excessive social cost for errors made by administrative staff or even judges who aren't really the targets of the rule's deterrent function.
I understand the argument that the price of exclusion is high. I really do. But I wonder if that approach misses the point about sort of compelling governmental respect for the Fourth Amendment across the board. When the court introduces the good faith exception, for example, doesn't it inevitably lower the incentive for the government as a whole to ensure their warrant applications are flawless? And maybe it lowers the incentive for administrative staff to maintain accurate, timely databases too?
But let's look at the scope of the Fourth Amendment itself for a second. You rely on the idea that this right is somehow absolute and requires an always-present exclusionary remedy. However, the text of the Fourth Amendment is actually, it's two clauses: the requirement for warrants to be supported by probable cause, and the requirement that searches themselves be reasonable. The text itself leaves open some ambiguity. Must every reasonable search comply with the warrant clause, or can reasonableness exist independently? Our legal landscape today is absolutely filled with specifically established and well-delineated exceptions to the warrant requirement, often based entirely on flexible reasonableness balancing. The Terry stop framework for brief detentions, the motor vehicle exception, consent searches, plain view, and so on. If the warrant requirement, which you hold up as foundational, is so frequently excused or ignored based on necessity, arguing that the exclusionary rule is always an essential component of the right seems, inconsistent with the current, very flexible legal reality.
I'm not quite convinced by that line of reasoning, because the existence of exceptions to the warrant requirement doesn't necessarily invalidate the need for a robust, rights-based remedy when the core right is violated. In fact, you could argue modern interpretations have actually strengthened the core right by moving beyond just physical places. The Supreme Court fundamentally expanded the Fourth Amendment's principle when it adopted the reasonable expectation of privacy test in Katz v. United States. Katz famously taught us that the amendment protects people, not places. This expansion, grounding protection in a subjective expectation of privacy that society recognizes as reasonable, it seems to me it demands an equally robust remedy. If we are protecting a person's entire life experience, not just their house, the remedy for violating that protection has to be powerful. You see this when the court considered the search of modern digital devices in Riley v. California. It noted that cell phones contain a digital record of nearly every aspect of their lives, and therefore upheld a very robust warrant requirement even for a search incident to arrest. This really shows that when the right to privacy is at its strongest, exclusion remains the necessary enforcement tool. And this focus on privacy in the digital realm, it leads us directly to the profound challenge of mass modern surveillance. The move towards a deterrence-only framework, I worry, actively diminishes protection against pervasive data collection. Consider the third-party doctrine, which traditionally held that when you voluntarily share information with a third party, like a bank or a phone company, you essentially forfeit your Fourth Amendment protection. But the Carpenter v. United States decision marked a critical shift, right? Requiring the government to get a warrant for historical cell site location information, CSLI, because the sheer volume and sensitivity of data involved made the expectation of privacy reasonable. But if we rely solely on deterrence,
what real incentive does the government have to abide by Carpenter? They could potentially use artificial intelligence and mass collection techniques to find crime correlations, and then, after the fact, maybe assert parallel construction. That is, they create a kind of false trail of evidence to claim they acquired the evidence legally, thereby skirting the probable cause requirements outlined in cases like Illinois v. Gates. Exclusion seems like the only mechanism that can truly compel the government to respect the rule up front.
I absolutely agree that the rise of digital surveillance presents unprecedented threats. I really do. But I approach the solution from a slightly different angle. The COT's reasonable expectation of privacy test, while philosophically expansive, is, let's face it, notoriously opaque and difficult for lower courts to apply consistently. It often leads to confusion and inconsistency in protection. Furthermore, we can't just ignore the traditional legal framework entirely. The principle established way back in Smith v. Maryland still dictates that voluntary sharing with third parties generally removes Fourth Amendment protection. While Carpenter certainly carved out an essential exception for deeply sensitive aggregated data like CSLI, we must remember that the government's legitimate interests, like national security or even crime prevention in high-crime areas, have to be balanced against the intrusion. This balancing test, which is really the essence of the reasonableness standard, is already how we address special needs cases like sobriety checkpoints or random drug testing, where warrants and even individualized suspicion are deemed impracticable. So instead of trying to restore a potentially unsustainable all-or-nothing rights-based rule, the focus, I think, must be on ensuring that the required balancing test is applied rigorously and honestly to curb excessive government intrusions.
But if the courts are supposed to balance the social cost of exclusion against the benefit of deterrence, how can they accurately measure the deterrent effect of excluding evidence that the police might otherwise have obtained through some secret parallel construction technique? It feels like the integrity of the judiciary is the only real safeguard against these kinds of sophisticated evasions. The court has to hold the line and say, look, we will not be complicit in this kind of fiction.
And my response remains that that line must be drawn where the benefit is maximized and the cost is minimized. I mean, if we find that police misconduct is widespread despite the exclusionary rule, then arguably the rule is failing in its deterrent purpose anyway, and maybe we need better, more direct forms of accountability. If the error is not malicious, if it's a structural or administrative failure, we pay an immense social cost by excluding reliable evidence, potentially letting guilty people walk free, without achieving any meaningful change in behavior. The only way forward, as I see it, is through a measured, utilitarian approach.
Well, we have established, I think, that the original, deeply rooted justification for suppressing illegally seized evidence was really about the protection of fundamental constitutional rights and the maintenance of judicial integrity, a principle that seems essential for compelling governmental respect and protecting privacy, especially in the digital age.
And we've explored how the modern court tends to treat the exclusionary rule more as a judicial remedy, one narrowly tailored to its goal of deterring deliberate police misconduct. This approach recognizes that a purely rights-based view often ignores the heavy social costs and the pragmatic limitations inherent in its application, particularly concerning errors where actual deterrence is, well, essentially moot.
The tension between recognizing the exclusionary rule as an inherent constitutional guarantee and viewing it as a mere pragmatic remedy definitely reflects a profound and ongoing debate about the proper scope of individual liberty against government power in, let's face it, an increasingly complex society that often utilizes powerful new surveillance tools.
Right, and this requires us to continually evaluate whether our primary allegiance is to the principle of judicial conduct and the moral authority of the courts, or perhaps to the pragmatic necessity of regulating police behavior and ensuring that the truth, where possible, is revealed in criminal trials. There is clearly much more to explore in the balance between the rights the Fourth Amendment guarantees and the remedies required to actually enforce them.